The president did not want the hidden information made public. The presidency, however, is not a private kingdom. This truth was affirmed by the Supreme Court of the United States, ruling 8-0 on this day in 1974. President Richard Nixon had to hand over tape recordings of his conversations in the Oval Office. The decision in United States v. Nixon marked the end of Nixon's presidency. 16 days later, he resigned. The 37th president had attempted to withhold the tapes. Nixon resigned on August 9, 1974, not because he was impeached, but because the political foundation of his support collapsed. Defenders ran out of arguments, legal protection failed, and the gap between his public claims and the official record became unsustainable. Before we get started, take a second to hit that subscribe button and turn on notifications so you never miss our latest videos. It only takes a moment, and it really helps us bring you more content like this. Now, let's dive right in. Political survival depends on more than just holding office. That sequence matters enormously right now because history has a way of repeating itself in patterns that are recognizable to those who pay attention. But what if I told you that the exact same institutional machinery that brought down Nixon, a trap built brick by brick over months, has just been triggered again? Only this time, the target isn't Nixon, and the trap is infinitely more dangerous. The resignation was not a sudden decision. It was the end point of an accumulation. Legal findings, political coalition fracturing, bipartisan convergence on accountability, and the specific moment when the people who had been defending the president ran out of defensible positions and told him the votes were not there. Back in 1974, the justices appointed by presidents of both parties, including Nixon himself, rejected the idea that a president possessed absolute immunity. They held that the president is not above the law. The tapes, once released in full, contained what the prosecutor suspected: evidence of Nixon's efforts to obstruct the FBI's investigation into the Watergate break-in. The so-called smoking gun tape showed Nixon not only knew about the cover-up, he directed it. And yet right now, in the high-stakes corridors of Washington, history is echoing in ways that should send a chill down the spine of every political insider. The reason the resignation inevitability framing keeps appearing around Donald Trump is not that commentators believe he is temperamentally capable of resigning. He has spent his entire public career demonstrating the exact opposite, that he digs in, attacks, and refuses to acknowledge defeat under any circumstances. No, the reason this framing keeps appearing in the analytical writing of people who study these things seriously is far more terrifying for the former president's inner circle. Those analysts are tracking whether the exact convergence that made Nixon's position untenable is building around Trump in ways that are historically recognizable. They are watching whether the legal machinery, the institutional pressure, the accumulated court rulings, and the progressive erosion of the political protection that has been keeping the most consequential legal consequences at bay are reaching the specific, volatile combination that historically precedes the total collapse of a presidency. Think about it. Once the truth was unavoidable in 1974, Republican support didn't just leak, it completely collapsed. More than the burglary itself, it was the conspiracy to hide it that undid the president. The lies to the public, the pressure on investigators, the systematic abuse of power to evade accountability. It's not the crime, it's the cover-up became a political axiom that defined an era. It became operationally and politically impossible to continue. And right now, at this exact second, something genuinely significant is happening behind closed doors that demands your absolute attention. The Supreme Court, the very institution many believed was firmly locked in a conservative posture, has quietly been building a legal landscape that is far more hostile to the specific claims of unlimited executive authority and personal immunity from accountability than any single dramatic ruling could ever be. You see, the nightmare for Trump is not one single bad day in court. It isn't a solitary unfavorable headline. It is the specific, inescapable architecture of what the court's accumulated rulings have built together across multiple terms and multiple cases. And when you look at how these pieces fit together, the trap becomes visible. Take the landmark immunity ruling. While it made headlines for granting broad protections for official acts, it quietly confirmed zero immunity for unofficial conduct and explicitly set up a brutal application process in lower courts. Secrets about presidential acts against the Constitution cannot be hidden merely for political convenience. The most powerful man in the country must submit to scrutiny when the law demands it. These are the standards the judges affirmed, concepts as old as the presidency itself, explicitly designed by the framers to guard against their greatest fear: a leader who confuses personal interest with the national good and believes no one has the right to question him. On that fateful day in July 1974, the system designed when recording devices were made of parchment, ink, and quill pens told the most powerful man on earth, no. And now, the modern court is doing it again. Look at the tariff ruling, where the court found he broke federal law by exceeding his emergency powers, simultaneously establishing the major questions doctrine as a binding, lethal standard for every future emergency authority claim. Look at the ongoing term decisions blocking National Guard deployments, constraining emergency orders, and progressively narrowing the administrative space within which unilateral executive action can operate without judicial invalidation. And look at the birthright citizenship cases, where the oral argument questioning from multiple justices, including core conservatives, signals that another major invalidation of claimed executive authority is looming just beneath the surface. Together, those rulings and pending decisions constitute a legal landscape that is demonstrably more threatening to the sustainability of a Trump presidency than anything we have seen before in modern history. The nightmare is the architecture, and the court has been building it, one decision at a time. Let's dissect how this trap actually closes. The immunity ruling created a three-tier immunity structure. Lower courts are now systematically applying this framework to find that Trump's most legally dangerous conduct falls squarely in the unofficial act zone rather than the protected zone. But the true nightmare dimension of the immunity ruling is not just what it found on day one, it is what it left unresolved, and what the brutal process of resolving it looks like from the inside of a campaign or a presidency. Every single immunity fight that a lower court conducts, every precise application of the framework to a specific category of conduct, is a public legal proceeding. It generates public filings, oral arguments, judicial opinions, and heavily documented findings about what occurred behind closed doors. These fights are not happening in sealed proceedings or classified vaults that the public can never see. They are happening in open public federal courts. They are generating published opinions that are accessible to every journalist, every legal analyst, every voter, and, most importantly, every member of Congress who is quietly deciding where their ultimate loyalty lies. Step by step, the courts are building an official record. This category of conduct is unofficial. This pressure campaign falls completely outside the scope of legitimate presidential authority. This coordination activity is the work of a political candidate trying to retain office, not a president exercising governmental functions. They are building an authoritative, public, permanently documented, and specifically attributed judicial record of what American courts have officially determined about his conduct. And that record is the operational nightmare. It is being assembled in broad daylight, one immunity ruling at a time, in proceedings that generate formal, written judicial opinions, not anonymous leaks, not unverified rumor, and not disputed political spin. It constitutes a documented judicial account complete with specific legal conclusions, specific factual findings, and direct citations to evidence that no political defense can simply brush aside as partisan witch hunts. When an Article III court issues a published opinion after reviewing sworn evidence, it isn't a cable news talking point. It is the law's official account of reality, and that account is becoming progressively more damaging with every passing week. And then, the second wall of the trap slides into place, the tariff ruling. When the court found that Trump broke federal law with his global tariffs, it wasn't just a technical disagreement over trade policy. It was a publicly documented Supreme Court-level declaration that the president acted in direct violation of federal law in an area where he had publicly claimed absolute unilateral authority. The political fallout of that specific finding cuts deep into the core of presidential credibility. A president whose signature economic policy, the absolute centerpiece of his economic vision, is formally declared unlawful by the highest court in the land, with votes joining from justices he personally nominated and celebrated, is a president whose core constitutional claims have been systematically demolished. And the practical consequences are catastrophic. We are talking about the potential forced refunds of tens of billions of dollars, immediate disruption to international trade policy, and a loud signal to every foreign government on earth that his executive declarations can be legally neutralized overnight. The legal defeat compounds into an operational governance failure, shattering the very narrative of strength that holds his political coalition together. And just when you think the pressure couldn't get higher, the third leg of the nightmare landscape hits with visceral concrete force, the civil fraud enforcement track. This is the component that triggers the overnight collapse dynamic because it moves through legal enforcement mechanics specifically built to resist political stalling. It does not pause for election cycles. It does not wait for congressional debates. The judgments are final. The appeals mechanisms have been run through. The enforcement,